You know, this setting is so perfect, and the words that have already been spoken are so appropriate, there really isn't much to add. But that doesn't mean that I'm going to sit down there and sign that pardon without trying to share some of my thoughts with you. I do thank all of you for being here today. It is a beautiful day, and there's never a bad day to do the right thing, right? But it's also a great way to kick off the new year and perhaps a new chapter in the state of Louisiana and in the country. And Don and I wish all of you a very happy new year. And may 2022 be the best year ever. And if not, may it certainly be better than 2020 and 2021. Thank everyone who's been so instrumental in making this happen this morning. Professor Bell, Keith, Phoebe, Kate, your family, Senator Murray, the District Attorney, Jason Williams, all of you for being here. But for those of you who believe this was the right thing to do and then work to make it happen, it reminds me that faith and works together are what we are called to engage in. While this pardon has been a long time coming, we can all acknowledge this is a day that should have never had to happen. 130 years ago, Homer Plessy bought a ticket, boarded a train right here where we sit, bound for Covington, just 40 miles to the north. And I know you know the rest of the story, and I'm not going to recite it for you. The subsequent Supreme Court case, as Professor Bell so powerfully described, led to generations of inequity. It left a stain on the fabric of our country and on this state and on this city. And quite frankly, those consequences are still felt today. Homer Plessy more than did his part to prevent that stain, and so did many others. And we honor them all today, and their names have been mentioned. I want to highlight today the one eloquent and courageous dissent from Justice John Marshall Harlan, who, I think it should be noted, belonged to a family that had enslaved people of color. He initially, though he was a unionist, he was not in favor of emancipation. But his views of race, equality, civil rights, they did change. And his dissent cogently and powerfully made the case that Plessy versus Ferguson was incorrectly decided. That dissent accurately predicted the damage that it would do to our country. And it inspired Brown versus Board of Education some 6 decades later. Further, Justice Harlan's dissent demonstrates that justice and decency dictate the absolute necessity that we come together this morning for this posthumous pardon, so that the last chapter in this saga exonerates Homer Plessy and celebrates his cause as right and just. In his lone dissent, Justice Harlan predicted that in time Plessy would prove every bit as pernicious as Dred Scott. The 1857 Supreme Court case that is universally condemned as the worst decision ever by that court, as it inexplicably held that the United States Constitution did not extend citizenship to people of African descent, whether they were free or slave, no matter when or how they came to be in the United States. A war was soon fought over the issue. The 13th, the 14th, the 15th Amendments were all added to the Constitution to effect change. But neither Homer Plessy nor any other person of color immediately received the benefits of that war, and the amendments sought to confer on them. Now, I have to admit, pernicious is not a word that I use very often. I concede that Justice Harlan's command of the English language is superior to mine, but the word perfectly fits because it means evil, fatal, ruinous, wicked. So I think I'm going to use that word a few more times this morning. And because I cannot possibly do justice in expounding on the righteousness of Homer Plessy's cause or in adequately illustrating the utter wrongfulness of the court's decision, I will recite a couple of brief passages from Justice Harlan's eloquent dissent. He wrote, and I quote, But in view of the Constitution and the eye of the law, there is in this country no superior, dominant, ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. It is therefore to be regretted that this high tribunal, the final expositor of the fundamental law of the land, has reached the conclusion that it is competent for a state, our state, to regulate the enjoyment by citizens of their civil rights solely upon the basis of race. The destinies of the two races in this country are indissolubly linked together, and the interests of both require that the common government of all shall not permit the seeds of race hate to be planted under sanction of law. What can more certainly arouse race hate? What more certainly create and perpetuate a feeling of distrust between the races than state enactments, which in fact proceed on the ground that colored citizens are so inferior and degraded that they cannot be allowed to sit in public coaches occupied by white citizens? That, as all will admit, is the real meaning of such legislation as was enacted in Louisiana. Those were Harlan's words, and he was right. The Supreme Court majority embraced racism and white supremacy as if the 13th and 14th Amendments to the United States Constitutions were mere ornaments without meaning or effect. Very sadly, it's not lost on me that one of the 7 justices who joined in the majority of the opinion was Louisiana's own, Justice Edward Douglas White. And I'll point out that much of his work on the court was admirable, but that was not his finest hour. The cause of the pardon that we gather today to celebrate, unfortunately, isn't limited to righting a historical wrong. The pernicious effects of Plessy linger still in terms of race relations, equality, and justice. We are not where we should be. And quite frankly, we're not where we would have been had at least 4 other justices had the same fidelity to the Constitution. The first 6 decades of the 21st century should have been filled with infinitely more promise and progress in race relations, and would have been had slavery immediately given way to equality and freedom. Instead, the Plessy majority ignored the plain meaning and purpose of the 13th and 14th Amendments and wrongly enshrined segregation into the law for the explicit purpose of declaring and promoting white supremacy. As immoral and factually erroneous as that was and is. The fictitious notion of separate but equal remained with us until the Supreme Court revisited the issue in 1954 in the context of public education and implicitly overruled Plessy. And in Montgomery, Alabama, 1 year later in 1955, Rosa Parks, in another very similar courageous act of protest, refused to leave a bus seat reserved for white passengers. I want you to think about this. That was 63 years after Homer Plessy did that right here. More than 6 decades, and it was still necessary because not much had changed. And it hadn't changed because the Plessy majority said it didn't need to change. Plessy also emboldened state legislatures and constitutional conventions to expressly promote white supremacy in a multitude of truly pernicious ways, including the 1898 Louisiana Constitutional Convention that sought, among other things, to negate the voices of black jurors by allowing criminal convictions with just 9 of 12 jurors finding guilt. This wrong was only righted 3 years ago by the adoption of a constitutional amendment requiring unanimous juries for criminal convictions in Louisiana. That the convention delegates were motivated by their zealous desire to perpetuate white supremacy is not debatable. Their writings and speech were memorialized in the official records of the convention. After Plessy, they had no reason to even pretend otherwise. Pernicious. Sadly, there are other ill effects of Plessy plaguing us still. Individuals have recently been nominated by the President and confirmed by the United States Senate as federal judges with lifetime appointments who cannot or would not state on the record in response to direct questioning that Brown versus Board of Education was and remains correctly decided. I can only conclude that those individuals allow for the possibility that Plessy was correctly decided. How sad. It ought to be disqualifying. The stroke of my pen on this pardon, while momentous, it doesn't erase generations of pain and discrimination. It doesn't eradicate all the wrongs wrought by the Plessy court or fix all of our present challenges. We can all acknowledge we have a long ways to go. But this pardon is a step in the right direction. And I am beyond grateful that I have a small part to play in ensuring that Homer Plessy's legacy will be entirely defined by the rightness of his cause and undefiled by an unjust criminal conviction. And I pray that we will all commit ourselves to further moving our country forward and, above all, loving one another and recognizing the dignity and equality of all of our brothers and sisters so that we can become what we aspire to be. One nation, under God, indivisible, with liberty and justice for all. So God bless you all. I am now going to read the pardon that I will sign with 27 pens in just a minute. Grant of posthumous clemency to Homer Adolph Plessy, pursuant to the Avery C. Alexander Act, to whom it may concern. Whereas Homer A. Plessy, date of birth March 17, 1862, and date of death March 1, 1925, was convicted of the following offenses and sentenced as shown. Orleans Parish Criminal Court, Section A, on January 11, 1897. The offense was violating the 1890 Separate Car Act, and he was sentenced to a $25 fine. Whereas the Louisiana Board of Pardons, in accordance with Article 4, Section 5 of the Louisiana Constitution of 1974, has recommended that I grant a pardon for the above listed offense to Homer A. Plessy. Now, therefore, I, John Bell Edwards, Governor of the state of Louisiana, recognizing the heroism and patriotism of his unselfish sacrifice to advocate for and to demand equality and human dignity for all of Louisiana citizens, do hereby grant a full posthumous pardon for the above listed offenses to Homer A. Plessy pursuant to the Avery C. Alexander Act of 2006, and do hereby direct you to act accordingly, and for so doing, this shall be your sufficient warrant and authority. In witness whereof, I have set my hand officially and caused to be affixed the Great Seal of Louisiana in the city of New Orleans on this 5th day of January, 2022. So, I'm going to ask the family members of Mr. Plessy, Judge Ferguson, Judge Harlan, to come and stand on the steps behind me while I take a seat and begin signing these pardons.
You watch it here?
Everyone on the down front. We're getting close.